right, sir, you're Linton Arsenault, and Mr. Arsenault is charged with failure to comply with sex offender registration requirements. We've gone over before with, yeah, I think that was maybe with Mr. Lewis before you were appointed, and what the offer was and rejection, and what's the status?
The state's not gonna go any lower, Judge. That's the only offer, and it's gone today. So he can take it today, or he can go to trial.
Okay, thank you, Mr. Hoffpower. Mr. LeBlanc?
And I've conveyed that to him, we've discussed it. And then my understanding is you can be one rejected or you can.
You want to go to trial? Okay, so I just want to make sure, and we've gone over this before, you understand if you go to trial and you're found guilty and those prior convictions are true, that you would be considered a habitual offender. Your minimum punishment would be 25 years, you understand? And it looks like that offer that was made is for going on count one only for a 10-year term in prison. Again, you've got every right to reject that and go to trial. Just want to make sure you understand possible consequences, options, and all of that. All right, then we'll get it set for trial, and Mr. LeBlanc.
So here's the twist. Arsenault rejects the plea deal. Just think about that for a second. 10 years on the table, gone just like that. He's now banking on beating the case at trial, knowing full well the law is stacked against him as a judge. Explained, if those prior convictions stick, the minimum punishment is 25 years. No probation. No early release magic. This is a textbook example of plea bargaining pressure. Defendants have the choice to gamble with a trial, but the consequences are so severe it feels like the system is cornering them into taking a deal. Let me ask you, if you were in Arsenault's shoes, would you take the 10-year deal or fight it out and risk a quarter century behind bars? Drop your answer in the comments, because I know opinions are going to be split on this one.
We'll begin preparation for trial. See, is Mr. Smith?
He's here, Judge. He was just, he's got witnesses outside.
Okay.
Is there something else?
I just want to get that started no later than in 5 minutes, so that Mr. Burbank, we can get him. He's got to go to another county. So if you want to let him know, I'm ready to get it. Oh, there you are. Are you ready to go ahead and get started?
We've got some here. I was just making sure that the mom got here before we get started.
Okay, is she here?
I don't know. Somebody will just arrive. I'm gonna walk upstairs.
Okay, I want to get started in 5 minutes, please. Charlie's. Mr. Rojas, let's see. You have Lawrence Jackson?
Yes, ma'am. We just got
Okay, let's see. Janisha Leonard, Mr. Coleman, and Mr. Rojas. Did you have that printed out? That's fine. I'll pull this up here. Good morning. You had that other stuff that he did printed out for me. Did you bring? Did I keep that on my desk? Thanks. Janisha Leonard. Okay. While they're getting her, let's Ridley McKinney.
Yeah.
Y'all got something you worked out, Mr.
Next up, we pivot to Rudy McKinney, and right away the tone in the courtroom shifts. McKenna's case is about probation violations. Nothing flashy, but deeply important. See, probation is like walking on thin ice. One wrong move and the judge can yank it away, dropping the full prison sentence on your head. Here, McKenna admits 2 violations: being out past curfew and falling behind on his fees. Sounds small compared to the charge he's on probation for: aggravated assault, family violence. But don't be fooled. Violating even minor conditions gives the state grounds to revoke. The real question is, will the judge throw him back in prison or give him one more shot?
Yes, Judge.
Okay, so don't get rid of that one off the docket yet. Good morning. Are you Rudy McKinney?
Yes, ma'am.
Or McKinley, I'm sorry. Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor. And I think we just go on counts 2 and 3 on this.
We do, Judge. We're not gonna go forward. We're gonna, draw allegations.
Okay, state's going to abandon 1. Will he waive the formal reading of that motion?
He will,
I
Your
just
Honor.
asked you that, I'm sorry. Mr. McKinley, in cause number 19-33345, I have a motion to revoke your community supervision. Shows that you were placed on probation August 1st of 2022 for the offense of aggravated assault family violence, and that was a 5-year term in prison that was probated for 8 years. Is that correct?
Yes, ma'am.
It alleges in count 2 that you were at a location other than, that you violated your probation because you were at a location other than your residence at approximately 10:24 p.m. April 9th of 2025. And is that true or not true?
It's true.
And then count 3 alleges that you are behind in your court assessed fees. Is that true or not true? And what is the status of that offense from count 1?
I believe it's been refused.
Judge, it was refused by our office.
Okay.
And the remaining witness is the same as this one, but therefore we refused. We're not gonna go forward with the allegation.
Okay. Is there a no contact order in the probation
Now,
though?
they're married, you know,
They're married, Judge, and
with
it's,
children.
I know the optics of it looks bad for the kind of offenses that he's on probation for.
Y'all hold it down just a little bit. Go speak.
So it looks bad for the kind of case that he's on probation for, but the complaining witness has come to my office, I've spoken with her, I think
We followed up with the judge. If we had it to move forward with.
Okay, I just wanted to check. All right. Did you enter your pleas of true to counts 2 and 3 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for me to continue you on probation and order 60-day jail sanction, and it looks like you've got 44 days credit. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. McKinley's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true. Find.
And here's where Judge West shows her style. Instead of revoking McKenna outright, she gives him a 60-day jail sanction, but lets probation continue. Now that's mercy with a sharp edge. She looks him dead in the eye and says, if you mess up again, you're doing 5 years in prison. This wasn't legal jargon. This was real talk. The judge even framed it as a life choice. Stay in a toxic relationship and risk prison, or separate and stay free. It's not often you hear that level of plain honesty from the bench. Honestly, it's powerful. Do you think this kind of direct, almost parental warning actually works on defendants like McKenna? Or is prison just around the corner no matter what?
Sufficient evidence to revoke your probation, but I'm not going to do that. I'm going to continue you on probation. I'm going to order a 60-day jail sanction as a condition for that. These allegations, you will get credit for 44 days. Here's the thing, something's going on, okay? And even at this point, if I think something's going on, the proof that is required for me to revoke your probation is not the same as it's required if we go to a jury. And if there's anything that happens again, whatever's going on between you and her, if y'all are not good together, then don't be together, because you're going to end up in prison. The offense that you're on probation for is obviously very serious. You've already agreed, when you got this probation, you already agreed to that 5-year sentence in prison. You violate your probation in any way again, you've got the 5 years. I don't care if it's having to do with her, if it's being out past curfew, if it's not showing up for appointment, this is it. So whatever's going on, y'all need to get whatever help you need. If it needs to be separated, then you need to be separated. Otherwise, you might end up in prison. So you have to figure out what's really best, to be in a volatile relationship in front of your children or to be in prison. You understand?
I understand.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. As soon as you're released from jail, first thing you do, report back to probation, get going on everything like you're supposed to. All right, good luck to you. Okay, did they get,
Jackson, I don't think it's been printed yet.
Miss Leonard, y'all have Miss Leonard? Come on up, Miss Leonard. Janisha Leonard, 3 cases are called. All right, you're Janisha Leonard. And Miss Leonard, in cause numbers 19-333-40 and 20-36095.
Now, things take a more emotional turn with Janisha Leonard. She's on probation for theft. But the new twist is heartbreaking. She's been in jail 14 weeks while her newborn daughter, born with a heart murmur, struggles without her. Leonard testifies that the baby can't latch onto a bottle properly, making breastfeeding separation a real health issue. This is where justice collides with humanity. The court can't just overlook her missed payments and unfinished community service hours, but they can't ignore a 2-month-old baby either. Judges face this kind of dilemma more often than you'd think, balancing punishment with compassion.
On probation for theft of property and theft of service, and a motion to revoke has been filed in each of those cases. There's a new offense indicted 250297 with the allegation of theft of property. And so that theft new allegation is from offense date of August of 2023. And so obviously that was some time ago. There's a motion, let me get to the right paperwork. In each of these cases, obviously alleging that new offense. Mr. Rojas has filed motion in each of those motion to revoke probation cases that I set a bond, that currently they do not have a bond. Those are deferred, correct? Are they both deferred? Let me double check.
I think they're straight probations.
They're straight probations?
They are.
Okay. So Ms. Leonard isn't necessarily entitled to a bond as if it were a deferred, but we're here to talk about that. Mr. Coleman has filed a state's reply to that motion. I have read and reviewed that and obviously understand Mr. Coleman's position. Mr. Rojas, you may go forward.
Call Ms. Leonard, John.
Ms. Leonard, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Okay.
Okay, Ms. Leonard, how long have you been in jail now?
14 months.
And it's my understanding that you've got a newborn baby at home? How old is that child?
3 months.
All right, and there's a little, you're having, or before you come in, you're having issues with breastfeeding or with feeding a child?
Yes, ma'am.
Tell the judge about how it's.
My daughter's been breastfed since she was hospitalized at 3 weeks old. She also has a heart murmur. And since I've been in here, they've had trouble with her latching on to a bottle.
So let me ask, it looks like in these motions, the primary allegation obviously is that new offense. And then there is some community service hours and then very behind in fees and fines. Other than those things, I've got probation here. And if you'll just state your name for the record, ma'am.
Linda Core.
And is there, other than those items, is there any other issues that you are having with Miss Leonard that I need to be aware of?
No, Your Honor.
Okay. If this new allegation was more recent, I'm not sure what happened with the timeline on this, and doesn't, for this purpose, I guess, doesn't really matter. But because it's been so long, and it looks like, other than some fees and community service, everything else has been going well, I'm going to grant the motion to set bond in cause numbers 19-33340 and 20-36095. Going to set the bonds in each of those cases at $5,000 in each case.
In the end, Judge West strikes that balance. She sets bonds at $5,000 on each probation case, plus $10,000 on the new charge. That means Leonard isn't walking free. She's still got to hustle to raise $20,000 in total, but she's given a chance. And the judge's message is crystal clear. Don't think you're off the hook. Start paying, start showing effort, or prison is next. What stands out here is how Judge West acknowledged Leonard's struggle without excusing her obligations. It's the courtroom version of tough love. Sympathy for the baby, but accountability for the mother. So I'll throw this one to you. Should judges weigh family hardship more heavily when deciding bonds and probation, or should the law stay blind to personal struggles?
And obviously, if you make those bonds, the first thing you do is report to probation and do everything you're supposed to be doing while you're on probation. Yes, ma'am.
Is that included with the $10,000 bond with the new charge?
You have 3 different bonds. You've got a $10,000 and 2 $5,000s. And so you need to get busy, because while this is pending, obviously would be, I would think, in your benefit to try to get some community service hours done, to get a job, start making some payments, show me and probation and the district attorney that you're trying, because just me setting bonds doesn't mean that you're out of trouble for this. You can still go to the state jail prison. So it's very important that you do everything that you're supposed to while you're on the probation, okay?
Yes, ma'am.
All right, we'll see y'all back at an announcement. We'll worry about that later, yeah. I can't imagine that's gonna be. Oh, I'm not gonna do, okay, I don't need that. That's all right now. Got it. Hallie Rolls, Mr. Rojas. And then we'll take a break, and I'm gonna have to do a hearing with Mr. Burbank. Mr. Burbank, I'll take care of your case next. We'll get started as soon.
So what's the takeaway here? For Arsenal, it's a high-stakes gamble, rejecting 10 years and facing the real possibility of 25. For McKenna, it's a sharp warning that his relationship struggles could cost him 5 years of freedom. And for Leonard, it's a tough reminder that being a mother doesn't erase probation obligations, even when life throws heartbreaking challenges your way. Judge Raquel West handled all of it with balance, firm when she had to be, but empathetic when the human side of justice needed to show. That's why she stands out. If you found this breakdown as eye-opening as we did, hit that like button, share this video with someone who loves true courtroom drama, and of course, subscribe so you don't miss the next shocking breakdown from Judge West's courtroom. And don't forget, drop your thoughts in the comments. Whose case struck you the hardest today?